Please give us a brief introduction.
Good evening, sir. My name is Irsheeta, and I'm a resident of Gadpos village. It is under Sambalpur district, and I have graduated in BA from National University of Study and Research in Law, Ranchi. I graduated in the year 2019 in the month of July, and since then I have been preparing for judiciary only. And my hobbies are to listen to music and to watch movies, dancing, singing. That's
Okay, fine. So we will start directly with the legal aspects. Okay, I'll start first with the procedural law. So Code of Civil Procedure. So all these procedural laws, Code of Civil Procedure, Criminal Procedure, and the Indian Evidence Act, are these three basically enacted after our independence or before our independence? And if you can give me the years.
So the Code of Criminal Procedure, uh, so the Indian Evidence Act was enacted before independence. The Criminal Procedure. So basically, I think all the three acts were enacted before independence only. But after independence, we have amended it and we have replaced all the acts except the Indian Evidence Act. So.
Okay, fine.
And also, so the Civil Procedure Code, which was enacted in the year 1908.
Okay. So tell me, who can amend the Civil Procedure Code?
So Civil Procedure Code is basically divided into two parts. One comprises of sections and the other part comprises of the rules. So sections can be amended by the Parliament only, whereas the power to amend the rules is vested with the High Court of the respective states.
Okay, good. Okay. So can you tell me what is the difference between the principles of estoppel and res judicata?
Yes, sir. So principle of res judicata is basically relates to rules of procedure. It basically relates to the court, or it is vested within the court or vested on the civil courts. Whereas rule of estoppel is a principle of evidence. It's an evidentiary rule. So res judicata is provided under CPC under section 11, where the courts are barred, civil courts are barred from initiating or taking any matter before it, or issue or initiating a trial before it of civil matters, where the matter is already decided by a competent court and it has conclusively decided by a competent court within the same parties and title and everything. And rule of estoppel does not apply on the courts as it applies in res judicata. Rather, it applies on the parties. So it is the action of the parties or the declaration or any act that one party does, depending on which or believing which the other party takes any action, and doing that so when he does that, the other party is not allowed to take back or to deny the truth of it. So both are different in that way. So
Okay, okay, good. So suppose a foreign court has given a judgment and that is to be executed in Indian territory. So what are the prerequisites for that execution of a foreign judgment in Indian territory?
So, foreign judgments, the requirement that is provided and provided for the execution of foreign judgment, or even for that foreign judgment to be valid in the Indian courts or in India, is provided under Section 13. So, Section 13 lays down that the judgment must be passed by a competent court. The judgment must not be in violation to the natural justice, or it should not have been obtained by fraudulent means, or it shouldn't be in ignorance of any Indian law or breach of any Indian law or any international law. So if these criteria are fulfilled, then a foreign judgment is valid. So in order to execute the foreign judgment, there are two ways. First is by simply filing a suit for execution, and second is by filing a suit under Section 44A of the Civil Procedure Code.
Okay, fine. So can you tell me what you mean by garnishing proceeding?
Yes, sir. So, garnishing proceedings are provided under Order 21, Rule 46A of the Civil Procedure Code, and garnishee basically means the debtor of the debtor. So, when there is a suit between two parties and the judgment debtor is ordered to pay some amount to the decree holder, then in that case, if the judgment debtor already has another debtor who owes him money, then the court, he can file the application before the court, and the court shall order the judgment debtor's debtor to pay the price or to pay the cost or compensation, whatever it is, to the decree holder. So that is the whole garnish order.
Okay. What do you mean by a summary suit?
Yes, sir. So summary suit has been provided under Order 37 of the Civil Procedure Code 1908. And summary suit basically means that these suits basically relate to promissory notes or hundi or bank notes, these kinds of suit. And these are very petty suits.
Okay. Okay. So
these are
okay.
so should I continue?
Yeah, please continue.
Yes, sir. So in these kinds of suit, the amount is not too much, and these are, one may call it petty suits in civil cases. So in that case, the law says, or the Civil Procedure Code under Order 37 lays down that it is not mandatory for the defendant to defend his case, and only if he sees any reason, or there are certain reasonable grounds for him to enter into appearance and present his case, then in that case, he may file an application before the court, and the court may allow him to proceed or to defend himself. So this is basically all about the summary procedure. So it is a short procedure as compared to other regular procedures.
Okay. Suppose a court has tried to reach, to one of the parties, and summons have been served, and person is not responding at all. Okay. And court has decided to go for ex parte decree. What are the considerations the court has to keep in mind while going for this? While going for a ex parte decree. Yeah.
So the consideration, basically passing of ex parte decree on the basis of the default of the other party to appear before the court is provided under Order 9 of the Act, on Order 9 of the Civil Procedure Code, and it says that even if summons has been served or duly served, and even if the other party is not appearing before the court, then in that case, court may proceed towards passing of the ex parte decree or ex parte proceedings.
Okay. So suppose there is some defect in the jurisdiction, okay, of a court. Let's say there is a defect in case 1 in the pecuniary jurisdiction, second the territorial jurisdiction, and number 3 the subject matter jurisdiction, okay, of the court. What are the effects on the decree passed in all these 3 cases?
So if there is a defect of subject matter jurisdiction, then the decree is nullity. It is not a valid decree. Secondly, so if there is a defect on territorial jurisdiction, unless and until there is a grave injustice or it cannot be set aside. It is a valid decree. It is a totally valid decree. Also, sir, with respect to pecuniary jurisdiction, even if a court did not have jurisdiction and it has passed a decree, then also it will be a valid decree unless and until grave injustice has been caused to the parties.
Okay. So then what is the difference between irregular exercise of jurisdiction and a nullity?
So I won't be able to answer that. Okay. I'm not able to frame the answer.
Okay, that is fine. Just a minute. Chrome रे देखियो जोटा लाइव चलती वो ऊपर है ठीक अछि Chrome तो नहीं Firefox टा बंद करके ऊपर रे लाइव चलती वो से लाइव टा स्टॉप कर दो और से थरे लिखियो डू यू वांट टू एंड द लाइव स्ट्रीम तो सेटा ओके कर दो ने अपन द स्ट्रीमिंग टा चली okay sorry so okay that is fine so let us now come to some other statutes. So coming to the Indian Evidence Act, okay, can you tell me what is the concept, okay, of res geste?
Yes, sir. So the doctrine of registry has been enshrined under Section 6 of the Indian Evidence Act. It basically means facts forming the same transaction. Section 6 lays down that even if a fact is not relevant, even if a fact is not the fact in issue, but if it is connected with the fact in issue in such a manner that it forms part of the same transaction, irrespective of the fact that it took place at the same time or the same place, or a different time or a different place, then in that case, it forms part of the same transaction. And this is known as the principle of res justice.
And you know the leading case laws, right?
Yes, sir.
What are they?
So R versus Bedingfield is a landmark case on the principle of res justice. So also uh, uh, Emperor R versus Ratton, I think so. I'm not
Okay.
able to
When you are
remember the
talking
name
about
exactly.
R versus someone, what is this R?
So
What is the meaning of
Shrek,
R? Okay, if you it's not an issue if you cannot pronounce it. What is the meaning? Just tell me that.
so I don't know. So
Okay, just check that. Okay, what is R, right?
okay,
Okay, and
so
okay, you have not done your master's degree, LLM,
no, so I'm no, graduation only.
only graduation you have done. You're not interested in higher studies. Now, suppose you are selected as a civil judge.
So
Do you since you have done your LLB from a national law university, do you have an ambition to have your LLM from a from a national law university, or even maybe you can try abroad? Okay, do you have that ambition, or you are okay with whatever qualification is you are having now?
so as of now, I have not thought about it. So
Okay, fine. So coming to continuing with proper your evidence. Okay, so tell me
evidence.
something. When can hearsay evidence be actually admitted as an evidence?
So hearsay evidences can be accepted as evidences. There are certain cases such as in admission, when there is under section 17, it's an exception to hearsay evidences. Then so when a confession is made to some other person, then also it makes an exception. So I can think of these two cases as of now. Also, I think so the principle of res gestae includes hearsay evidences.
Mhm. Dying declaration will be included here. Is dying declaration hearsay evidence? There is no
Yes, sir.
proof
Dying
of
declaration is a hearsay.
also hearsay evidence. Okay, fine. Okay. So this evidence act basically, okay, it is we have taken it mainly from the British jurisprudence or the American jurisprudence?
So British jurisprudence.
British jurisprudence. Okay. Um, so
Yes.
let us go to CRPC. Okay. So can you tell me, what is the process? Okay. In case of criminal investigation, okay,
So,
a particular accused, okay, he has some evidence. Let's say he has that evidence in his car, okay, and the police does not have a search warrant to search his car, right?
so
So without the warrant, can they break into his car and what they consider as evidence, can they collect it? Will that evidence be admissible in Indian court of law?
yes, sir. They can investigate the matter, or they can also search for for an object, even if they do not have a warrant for that. It is provided in section 165 of the Criminal Procedure Code that if the investigating officer has enough reasons, or he has reasonable ground, and if he thinks that if delay is caused or he does not proceed immediately, then the evidences might get lost. So in that case, he has to write a written statement. He has to sign that written statement, and he has to forward that statement as soon as possible to the magistrate having the jurisdiction to try that particular case, and he can proceed with that. So, but he must have reasonable grounds to do that.
Okay. So tell me what you mean by anticipatory bail. And let's say I go to the court and I am, basically asking them for an anticipatory bail for a crime or something which has not been committed till now. Can the court give me anticipatory bail in that case?
So the concept of anticipatory bail has been provided in Section 438 of the Criminal Procedure Code, and it lays down that when a person has reasonable apprehension that he may be arrested for any non-bailable offense, then he may file an application before the Honorable High Court or the Court of Session for granting him the anticipatory bail. And when such bail is granted, then whenever an arrest warrant is issued or whenever a police officer goes to arrest him, he can show that he can show the bail or order from the Honorable High Court and the Court of Session, and he can relieve himself from getting arrested. So this is the whole concept of anticipatory bail. And so, answering your second question, that when an offense has not been committed, then I don't know if there is a straight jacket formula or there's a straight answer to that, but according to me, if an offense has not been committed, then why should he have a reasonable apprehension that he might get arrested if he has not done anything? Then but sir, I think reasonable apprehension plays an important role. So even if a crime has not been committed, but he's fearing that someone might trap him without having committed any offense, someone wants to defame him, then he may, I think, file for anticipatory bail. So
Okay, you used a term that anticipatory bail will be given generally in case of a non-bailable offense. Is it also applicable to bailable offenses?
No, sir, it is not applicable to bailable offenses. So, Section 438 lays down non-bailable offenses. So if it is a bailable offense, then he may get bail as soon as he gets arrested. So there is no need for anticipatory bail.
Okay, fine. So now let us go to your optionals. So what optionals you have taken?
So first is IPC and law of torts. Second is personal law, and third is law of properties.
Law of properties. Okay. So let us start with property law. So can you tell me what is the principle of less penance?
Yes, sir. So the principle of less pendants is provided under Section 52 of the Transfer of Property Act, and less pendants basically means when a suit is pending. So principle of less pendants lays down that whenever a suit is pending before a competent court, and the subject matter of that particular suit is any immovable property, and so any party, either party cannot transfer that immovable property to any other person, which is the subject matter of the property, and when transferring it, or if it is being transferred, then it may affect the rights of the other party. So this is the principle of less pendants, so that in order to maintain the status of the particular suit, in the principle is introduced. So
okay, that is fine. Okay, so this word property, has it been defined in the statute?
Yes, sir. Properties are of two kinds, movable and immovable. Both movable and immovable property is defined under Section 3 of the Transfer of Property Act.
Okay, so your other optionals are personal law, right?
So, yes, sir.
Personal law. Can you tell me what are the various forms of Shia or types of Shia marriage and Sunni marriage under Mohammedan law?
So, yes, sir. There are three kinds of there are three kinds of marriages in Sunni law, and there are two kinds of marriages in Shia law. Yes. Under Sunni law, there is a valid marriage, there's a irregular marriage, and there's a void marriage. But under Shia law, there's no irregular marriage, there is just a valid marriage and a void marriage.
And you do not remember the terms?
Islamic terms.
Yes.
So valid marriage are known as batil, and void marriage is known as fasil, and so irregular marriage, I don't know the terms.
Okay. Okay. Same thing about the Hindu law. So in customary Hindu law, what are the forms of marriage?
So there are three forms of marriage. So one is valid marriage, another is voidable marriage, and the other is void marriage. So
That you're saying according to the like codified laws, right? I'm asking about customary laws. Like that is a Asura marriage, Prajapataya marriage. Many such forms are there, right?
so
Customary Hindu law. Yeah.
yes, so there are Brahmana, Asura, and there are certain kinds, but I don't remember.
Okay, fine. So, do you have any idea in the difference of laws of adoption for a Hindu couple and a Muslim couple? Laws of adoption.
Yes, sir.
Hmm.
Yes, sir. So for Hindus, the adoption laws are regulated this is basically regulated by the Hindu Adoption and Guardianship Act, and it lays down the qualifications or the criteria that is required for a valid adoption under Section 6 of that particular act, and it says that if a couple who is adopting, then the consent of each party is required, and if a couple who is giving in adoption, then also their consent is required. They must be of sound mind, they must be major and everything, and also when the person who is, or the child who is being adopted must not be above the age of 15. He must not have been married, and the couples who are adopting must not have a valid son or son's son or daughter's son. These are the criteria that is laid down for Hindu marriage. While for Muslim marriage, or while for a Muslim couple, the Shariat Act does not allow adoption. So it is, they can adopt by or through Juvenile Justice Act, I think, but they cannot adopt. The Shariat Act bars adoption in Muslim community.
Okay, fine. Your other is what you have taken the other one,
Privacy and
crimes and torts, right? Okay. So,
yes, sir.
can you tell me exactly what is the title of the section 498A of IPC?
So it defines cruelty, but I don't remember the exact title. I think it is cruelty defined.
Okay.
I think I don't.
Have some changes taken place over the last 5 or 6 years after some observations made by the Supreme Court? Are you aware of this on section 490?
So relating to this, uh, so there has been an amendment, but I'm not aware of it. So I won't be able to answer that. So.
Mhm. Earlier, I think it was the arrest was almost imminent in these cases, but now the Supreme Court, after many cases of false use of this, has given certain guidelines to the investigating officer that before you go for arrest,
Okay.
you have to be very sure of what the things are. Okay, fine. So,
Okay.
what is the difference between dacoity and robbery and theft?
So, so first of all, the difference, I would like to mention the difference between dacoity and robbery. So robbery is the same thing as dacoity, but the only difference between these two is when robbery can be committed even by one person or two person or three persons, dacoity requires at least five persons or five or more persons conjointly committing robbery. Then it amounts to dacoity. When robbery is committed by five persons or more conjointly, then it amounts to dacoity. And speaking of the difference between theft and robbery, is a theft. Uh, Robbery also includes theft. Theft becomes robbery when there is a presence or there's an element of imminent fear of death or wrongful confinement or causing of grievous hurt while committing theft, or while taking away the property after commission of theft. When these elements are present while committing theft, then it amounts to robbery, sir. And of course, there is a difference in punishments for theft, robbery, and dacoity, sir.
Mhm. Okay. So, if the motive, okay, of a crime, the mental part or the intention cannot be proved and a crime has been committed, so can the courts acquit the person, the accused? Suppose a person, okay, is accused of killing another person, murdering another person,
So,
and it is found that like he has no connection, there is no intention to kill that person. Okay, uh,
so,
mens rea was absent. Okay, but actus rea was
so,
present. So in that case, what will happen?
so if we did not have a mens rea or intention to kill that person, then he won't be held liable for murder. Rather, he will be held liable for culpable homicide not amounting to murder.
Okay. Um, is there the concept? Do we have the concept of manslaughter in Indian law, as it is there in the American law, and how it is different from murder, manslaughter and murder? Are you aware?
So, no, sir, I'm not aware. So,
Okay, okay, fine. So, what have you heard about sedition? Which section
yes, sir.
deals with sedition?
So, sedition is dealt by Section 124A of the Indian Penal Code. It lays down that whoever by words, speaking or written or any representation of any kind tries or attempts or causes to bring hatred or a feeling of dissatisfaction towards the government established by law, then in that case it will amount to sedition. However, there are exceptions. So, if a person is doing all those things without any intention to cause dissatisfaction towards the government or hatred towards the government, and only he's doing that to bring the attention of the government towards any measures or actions taken by the government and amending that or improving that, then it does not amount to sedition. So,
So suppose 10, 15 people in a university, they are saying that, we want a division of India or Bharat tere tukde honge, etc. Do you think as a
so,
student of law that, this sedition, law of sedition should be applied on them?
so no, sedition shall not be applied in this case because the section clearly says that it should be against the government that is established by law, not the country. So if they are saying the government, the present government that is ruling the country, if they say anything against them or try to bring hatred against them, then it would amount to sedition. Not saying anything against the country would technically should lead to the offense of sedition. So.
So in a sense, you are saying that the government is at a higher pedestal than the nation.
No, sir. So there are laws in which if somebody commits insult or somebody does any act against our country, so there are laws for that also, sir. I'm not aware exactly of the act, but
Okay.
there is certain act which also punishes if people don't stand for national anthem. So these are they cause any cause any disrespect to our national flag. So there is a act, sir, but this particular section deals with central government or the government that is ruling, sir. That is all I want to say, sir.
Okay, that's fine. You told about national anthem. So, in the recent past, the Supreme Court has also, said that during films and all, one should stand up. Okay, and later or maybe they
So,
just toned it down. Okay, what is your view that even
so,
wherever should the national anthem be played anywhere, everywhere, and anytime or every time? And according to that, wherever it is played, you have to stand up. Do you agree with that, or it should have certain timing and certain place where this national anthem should be played? What is your view?
so, so my view is we should respect our national anthem. We should stand up whenever the national anthem is played because this is about our country. This is a very honorable thing for us. But sir, having said that, I also believe that there should be a timing because not every time one can play national anthem because it's not only it is actually in a way disrespectful for the national anthem as well. one cannot play national anthem anytime, anywhere. It should be played at a proper time, at a proper place. And having said that, people should respect the national anthem whenever it is played, but it shouldn't be played anytime and anywhere. So.
Okay, fine. So that will be the end of the interview. Thank you. And if I give you the feedback, yeah, your answer and all is very good. Okay. And those areas which you do not know, you're directly saying that I do not know this. So that is very good. So no, do not guess or do not bluff. Okay. So from my point of view, I think you are prepared. Okay. And this interview is always a 60-40 thing, like 60% of the questions you will be able to answer, and 40% you may not be able to answer. It's not a big deal. So don't worry about if you are unable to answer 4 or 5 or 6 questions. Okay. But your presentation is good. Okay. And if your written marks are good enough, I feel that you will get a good rank. Okay.
So how, if I ask you how much mark would you give to me?
Okay, for today's interview, I'll be giving you around 65 out of 100. Okay, so you try to push it up to 80. Okay, but 65 you will get. I generally am a bit reserved while giving marks. Okay, so your actual mark may be more than this, but then I'll be a little bit traditional in giving the marks. Okay, so 65 would be for today's interview. Okay, although whatever questions I asked, you have answered it pretty well. Okay, one most important to remember that maybe sometimes it's the attitude that matters more than the content. At no point of time, the interview board should get a feeling that, like the candidate is having a know-it-all approach or all. You have to be very humble. Okay, so that is there in your speech and expression. So that is something really that is a big plus point. Okay, so just maintain that.
Okay, sir.
And just another thing is that, if you do not know something, you are directly saying, sir, I'm unaware or I do not know. That is a very good habit. Just continue that. Okay, don't say anything which is wrong or anything, on which you have some apprehension. Okay, if you know 50-50, then whatever you know, surely only that part tell them, and the other part you say that I do not know. Okay, no guessing, no bluffing, right? So that is a very strong point that you're having. Okay. So all the best.
Sir, and what about the eye contact? Was it better this time?
Yeah, this time it was better because the eye contact is a thing. Now you're looking at the camera, right? So when there are like 2 or 3 people, when you go, okay, to the OPSC interview, so just shift your eyes also between, right? So the person who's asked the question, 90% time look at him or her, and then other people who are sitting, just otherwise it becomes monotonous, right? So just look, but line of sight always will be the eyes.
So, and one more thing, sir. So I was hoping to join the 10 classes, the second batch.
Yeah, that you can do. I'll just stop the recording, okay? And